Welcome to today's program, COVID-19, What Have We Learned? Legal Trends and Practical Tips for Real Estate Developers. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the Q&A box on your screen. Now, I'd like to turn it over to David Blake.
Thank you for joining us today for our program titled COVID-19, What Have We Learned? Legal Trends and Practical Tips for Real Estate Developers. Next slide, please. It's a disclaimer, I won't read it. Next slide. Okay, my name is David Blake. I am a construction partner in Seyfarth Shaw's DC office. And joining me today are three of my colleagues. Mark Johnson is a real estate litigation and construction partner in Chicago. James Evans is a real estate finance partner in New York City. And James OBrien is a real estate partner in Washington, DC. Seyfarth is a full-service law firm. We practice virtually every area of the law. If you have any legal questions or issues, please reach out to us. We'd love to see if we can be of assistance. We have approximately 900 lawyers spread across 12 offices in the US, as well as offices in London, Australia, and China. Next slide, please. Today's program has been designed to be very practical and designed specifically for real estate developers. We're going to be discussing with you COVID-19 language and clauses specifically for construction loans, for construction contracts, and for leases. And then we're also going to be discussing litigation trends involving COVID-19 in the real estate space. We're going to progress through the program in four main chunks. First, Mark Johnson is going to provide us with our litigation overview. And then we're going to go through the program in the order of a real estate development project. So first we need money. Dan Evans is going to talk with us about COVID-19 language and clauses for construction loans. Once we have our money, we need to build our project. I'm then going to come in and talk with you about COVID-19 language for construction contracts and COVID-19 riders for construction change orders. And once we've built our project, we then need to generate revenue. So at that point, James OBrien is going to come in and talk about COVID-19 language and clauses for leases. That will take us to approximately the 45-minute mark, at which time we have reserved 15 minutes for questions and answers. During the course of the program, please type your questions into the chat feature. I think that's in the bottom right corner of your screen. We will look at those at the end and get to as many of them as we can. At this time, I would like to turn it over to Mark Johnson for the litigation overview. Mark?
Great. Thank you, David. By far the biggest news from last year affecting the industry, which really continues in full force this year, has been the impact of COVID and government shutdown orders as affecting a variety of contractual obligations. Most prevalent was the impact of rent obligations, for shutdowns entirely or the capacity restrictions when they came back online and tenants were able to reopen. The vast majority of claims involved developers and landlords filing suit against tenants. Approximately 25% of the suits that we have seen, though landlords and developers also joined claims for possession, seeking eviction in addition to the outstanding rent. However, our experience has been that most really didn't want to take space back at all. They asserted those claims to gain some type of leverage, but they understood that they actually took the space back, it was going to trigger some mitigation obligations that they had. There was a much smaller segment of lawsuits where the tenants actually filed affirmative claims seeking complete relief or outright termination of the lease itself. For the most part, those lawsuits have not been very successful at all for the tenants, and they kind of miscalculated in that regard. Here at Seyfarth, we've been involved this past year and a half on all sides of these issues. I'm actually co-chair of the firm's real estate litigation group. First, if you want to go to the next slide, please, we're going to discuss the impact of force majeure clauses in litigation. Then we'll look at some of the more common equitable defenses that have been at play. Force majeure is really a French phrase that means superior strength. It's something that overwhelms the circumstances. It's an event beyond the party's control that prevents it from performing its obligation. Now, the circumstances can be foreseen or unforeseen. It's important to note that if it's a foreseen event, the parties know about it going into the contractual relationship, then that needs to be addressed somewhere in the contract. Otherwise, courts have found that the risk of loss falls on the party unable to perform. Courts look for a couple key aspects of force majeure clauses. The first, a typical force majeure clause will contain a list of specific events: strikes, lockouts, wars, acts of God, all the kind of same verbiage that folks on this call probably are familiar with. Many clauses we have found in our representation of clients the past year and a half also contain government restrictions or regulations as qualifying events of force majeure. Very few have identified public health concerns or epidemics, pandemics, which I think that's going to change. I'm sure James will talk about that during his piece. Depending the second aspect of what courts look at is some type of a catch-all clause. A lot of these provisions contain, or any other cause beyond the reasonable control of the party, that's designed to be of a, capture events of a more general nature that are not specifically listed. And a lot of developers and landlords have tended to think, that's their savior. They're going to be able to rely on that. Really, what we have found is that depending on jurisdiction, these catch-all clauses may be narrowly or broadly interpreted. There's a fairly well-established body of case law out there applying the rule of contract construction known as ujusdem generis, which simply means the general follows the specific. And in those situations, courts have concluded that catch-all language is not to be given its widest possible scope, but is limited to only the events that are of the same general class as those specifically identified. Our experience has been that developers and landlords have tended to embrace force majeure clauses, and the reason for that is in most commercial retail leases and development projects, those force majeure clauses contain carve-outs for monetary obligations of the parties. So that's what our experience has been. How about the next slide, please? What happens where the contract does not contain a force majeure clause, or it contains a force majeure clause that failed to sufficiently identify government orders or public, pandemics or health concerns, or like we just discussed, the catch-all language itself was deemed insufficient to capture the event. Parties have been turning to common law equitable doctrines to excuse performance, the most common of which are listed here. Now, bear in mind that these are equitable doctrines. So judges are asked to look at things like fairness and public policy, the white hat or black hat, as it were, of the parties to the lawsuit, who's acting reasonably, who's acting unfairly, who's trying to recover too much, et cetera. The first two, frustration of purpose and commercial impracticability, are really very common. Neither of those prevent performance. For under the frustration concept, performance is still possible, but the purpose of the contract has been substantially frustrated by a supervening event beyond the party's control. Commercial impracticability is similar, where performance is still possible, but it would be so extremely burdensome or onerous that it's really impracticable or inequitable to require that party to go ahead and perform. The last one is impossibility, where a party's performance has actually been rendered impossible. It's really kind of like the common law equivalent of the typical force majeure clause that we just looked at, which speaks to a party's inability to perform. But here, the dynamic difference is that the doctrine of impossibility doesn't contain the carve-out for monetary obligations that you see in many contract clauses of force majeure. There are some other common elements that the courts have identified for each of these defenses. The supervening event must be outside the party's control. The occurrence of that event was not the fault of the party seeking relief, and the party must not have assumed the risk of that occurrence, either in the form of expressly assuming it somewhere in the contract itself, or, as I mentioned a few moments ago, the event itself was reasonably foreseeable and the party did nothing to protect itself in the contract. The risk of loss will fall on it. Now, it's important to note that there's a whole body of case law out there that's pretty consistent across the jurisdictions that provide that mere financial hardship is not sufficient to trigger these doctrines. Otherwise, everyone would be relying upon them. Only if the inability to perform results from the occurrence of something, the non-occurrence of which was a basic assumption on which the contract was made. Another consideration the courts have been giving some thought to is the party seeking to rescind the contract altogether or simply seeking to pause performance for a temporary period. In the COVID era, the shutdowns were, for the most part, temporary, lasting from a few months to maybe several months, 6, 7, 8 months. But a lot of these contracts are 10-year contracts, and the courts have been reluctant to grant rescission or permanent relief for temporary periods of shutdown. There have been lots of courts out there who have been able to willing to apply these doctrines in a temporary fashion. Okay, why don't we go to the next slide? Here I wanted to pull together some key cases from the litigation perspective that we have seen. This is just a representative sample. There are cases that have come out this year. The first couple cases have ruled in favor of the landlord. The last two have ruled in favor of the tenant. But all these cases talk about the intersection of force majeure clauses and these common law excusability doctrines that we've just discussed. So they're quite across the board. So some key themes is that where you do have a force majeure clause that identifies government preemption, that pretty much is going to it's been the end of the dispute. Probably won't have time to go through all these now. I did want to just highlight the Cafe Nero case there, which was kind of interesting because, again, all these cases discuss all these doctrines. But in that case, there was a force majeure clause that identified government order. And it also contained a monetary carve-out excusing that said rent obligations were not permitted. So the landlord thought it was in like Flynn, it filed a motion for summary judgment. The court actually denied the landlord's motion, entered summary judgment for the tenant for just the temporary period of shutdown. There, the court concluded that the doctrine of frustration of purpose, which we just discussed, was the prevailing remedy here, and just kind of ignored the force majeure clause. And that was kind of the only case I've seen where the court really went through the distinctions between the two. The court found that the doctrine of impossibility and force majeure were prevention, but that really didn't apply here. So anyway, I call those to you. These are all good readings. And if you have any questions afterwards, please ask me about them in the chat session. Okay, so let's move on then to the next slide, please. The first wave of developer, landlord / tenant litigation involved the application of the force majeure and common law excusability defenses that we just discussed. The second wave that we're seeing now deals with the application of other contractual provisions. One of the most important ones that we have seen are cotenancy provisions and their interplay with force majeure clauses. As everyone on the call probably is generally familiar with what cotenancy clauses are, they provide that if a specified anchor tenants stop operating for a period of time, or if a percentage of the overall leasable area of a center is not occupied, then for that period of time, the tenant's rent obligations are abated or reduced. If lasting long enough, then perhaps you would have some termination rights. A lot of tenants have turned to these clauses during the government shutdown periods. It's not a developer-landlord breach. You don't need to establish you did anything wrong. It's more of an if X, then Y type of situation. It's really, we found, been kind of like a soft belly, as it were, for the litigation context in these issues. Now, where developers have succeeded, it's where they've had some kind of protections specifically embedded within the co-tenancy provision itself. These are listed here. You have to wait 60, 90 days or 6 months before the remedy of reduced rent kicks in. Is there an operating requirement? If the tenant itself is shut down, then should it be permitted to avail itself of the remedy of reduced rent? And we haven't really seen too much of a tie-in with force majeure clauses, either providing that there's some kind of crossover so the co-tenancy doesn't kick in, or provide in the co-tenancy provision itself that if one of the anchor tenants is somehow unable to open and operate due to some type of event of force majeure, then the co-tenancy clause is not triggered. Finally here, this case just came out, and it's really the first published case that we've seen. You won't be able to have time to discuss too much of it, but where the court did conclude that the co-tenancy clause was not implicated by the force majeure clause, such that the tenant was permitted to avail itself of the remedy of co-tenancy during the period of government shutdown order when the other anchor tenants were also closed. Here, the provision did not contain any of the landlord protections that I just referred to. And actually, this case, Seyfarth actually represented the tenant in this case. So it'll be interesting to see if there's going to be a wave of additional published decisions. All right, that's all I have for now. We covered a lot of ground, but I do want to turn it over to Dan Evans, who's going to discuss real estate finance.
Thanks, Mark. Listening to you take us wonderfully through that, I'm struck by the fact that we're really attempting to put a year and a half of all of our lives and all of our experiences over the last year and a half into 10-minute kind of sound bites almost. There's a lot out there to be discussed. There's a lot of lessons that have been learned. Folks, we really are interested in hearing your questions. Please do feel free to ask them. If we don't have enough time to get to all of them, please do feel free to reach out to any of us. So taking us through, I guess, painfully, the last year and a half, I guess there's an old saw. If you owe the bank $1, the bank owns you. If you owe the bank $1 million, you own the bank. I guess what we've seen in the past COVID period is if you have 1 million borrowers, each of whom owes the bank $1, the bank's in trouble when none of them can pay. Next slide, please. So just kind of putting it into perspective is kind of what we've seen over on the finance side of things, both the borrower side and the lender side. COVID hit, the world shut down. We were basically given 2 weeks. We had lender clients calling us up and said, hey, which of your loans can close in 2 weeks? Those are the ones that are going to go. The other ones, we'll wait and see. So it was kind of a hurried work from home type environment. Deals were closing left and right. And then all of a sudden there was silence. Folks didn't know what was going to happen. We all thought it was 2 weeks and it was over, and we were all wrong. So next, short-term forbearances. Lawyers weren't even involved in a number of these. We had lender clients sending out, letters to their borrowers saying, "Hey, congratulations, you get a 1-month debt service holiday. Everything's going to be fine by next month. It'll be great." That obviously didn't happen. So then we started talking longer-term modifications, forbearances. We had a couple of mall clients, a couple $100 million deals a piece. Asking to go out until the end of the year with their forbearance, and very, very smart business people laughed at them because we all knew it was going to be done by the end of the summer. That didn't happen, but by the end of the summer, you started seeing a lot of institutional bridge lenders really jump back into the market and start making dollars available for folks. There was a second round of the longer-term forbearances and modifications, which took us until a couple of months ago. Now we're starting to see recapitalizations. You're seeing a lot of preferred equity money coming into deals. You're seeing some mezz coming into deals, preferred or mezz disguised as preferred equity and just equity investments in general. And I think that's going to take us through the end of the year. We're probably going to see a pretty busy through the year end. After that, a lot of these foreclosure moratoria, are expiring. The creditors' rights folks are anticipating an uptick in lenders starting to make tough decisions and really picking between winners and losers. Next slide, please. So kind of as part of the lessons learned, knowing your lender during the modification forbearance stage of this became really, really important in formulating strategies and figuring out how you're going to work your modification conversation with your lender. Each class of lender, I should say, has very different incentives that are motivating them. Life companies, we're kind of going from most conservative to least. Life companies, long-term investment timeline, they have reputational risk. It's primarily relationship-based lending. You saw a lot of kind of very friendly modification conversations taking place. Generally speaking, things got done. There wasn't particularly a real rush to get things done, but they did. And again, it was really relying upon the reputation. It's important when dealing with a life co-lender to realize that they are very, very concerned about that their money's invested in order to pay out claims, pay out annuities and the like. So they don't have much room to maneuver on debt service on the interest side of things, but we did see some principal payments being pushed back and some other fun things going on. Bank loans, by and large, we found that bank lenders were dealing with, anecdotally speaking, regulatory pressures where the government was saying, hey, we know that you're supposed to meet all of these tests. We're just going to kind of turn a blind eye towards some things because we realize that the economy is in a mess. We really don't want to see a wave of foreclosures or whatnot. So the banks kind of took a slower pace to things as well. CMBS deals, which kind of takes you mostly out of construction, but we do have a permanent loan at the end of these projects. BP buyers were calling the shot. They were a little bit more aggressive, but honestly, the sheer scale of what was going on somewhat overwhelmed the servicers. So again, you didn't see that rush to foreclosures. The other capital markets, the CLOs, funds, other alternative lenders, this was interesting because you had there's clauses in many of the warehouse line documents, the repo documents, even certain of the CLO offering documents that says basically a loan will no longer qualify once it goes 60 days past being current. So there was a lot of pressure. There was a lot of room to maneuver as a borrower in structuring kind of a path forward through COVID with these other types of lenders. But at the same time, you kept on having that 60-day clock ticking kind of in the back of your head. So there was smaller things were done more frequently. Jim, this is an overview. Everybody does things a little bit differently, but that's kind of something that we saw really coming out of it, where you didn't necessarily see this in prior downturns. This incentives driving how a lender was going to respond to what was going on. Next slide, please. So now we get to the clauses part of this segment. COVID really just wreaked havoc on financial covenants. If you don't have tenants paying rent, all of a sudden you might find yourself in a cash sweep. Your debt service coverage ratio goes down below whatever the trigger event may have been in your documents, and you have a performing property, but now you're in a cash sweep. Extensions. We had a number of folks with shorter term debt who were coming up on extension periods, and all of a sudden they found that that they've been meeting all their criteria all the way along, but now that they don't meet debt yield test or they don't meet a DSCR test. Possible thoughts for future document negotiations from the side of the borrower. For cash sweeps, negotiate a one-time get-out-of-jail-free card, as they call them, to actually completely turn off your cash management. If your lender is sweeping everything that you have and putting it into an excess cash flow account, even if you cure, they will typically start having the funds run through the cash management waterfall and go back to the borrower, but there's cost there, there's expense. Lenders hate to actually turn off cash management entirely because A, they're afraid they're going to be going in and out, and that it takes time, it costs money. They just want everything set up once the trigger goes. But you know, in your documents, take a look at the triggers. Take a look at the idea of again, a one-time. We shut off cash management entirely. The lockbox closes after we cure. If you want to, tie it to government shutdowns. Tie it to what you see fit. But really try to figure out a way to get out of that cash sweep as quickly as you possibly can, and to get out of it entirely. On the extension conditions, what we saw was clients who had negotiated some sort of an option to pay down the loan in order to satisfy those financial covenants tended to have a little bit more wiggle room in what they were trying to do. Again, by and large, lenders were willing to make deals, to talk to people, but it was very helpful being able to point to a document and say, okay, you know, the property is not throwing off a ton of cash right now. We know it's going to in a couple of months, but the numbers are trending the right way. We'll pay you down a little bit, and who doesn't like that? Other options there: letter of credit, post it as additional collateral to bring down your DSCR, your debt yield tests, and you can even get that back after something again. Though I doubt something like this will happen again, we're all on notice. So if something interrupts the markets in a short-term basis, it gives you a way of getting a little bit more flexibility in general. So problems that we've seen, kind of inadvertent problems that we've seen. Many loan documents say, okay, once you start getting tenants in, if they go dark, we're going to put you into a cash sweep, or other bad things are going to happen. Historically, tenants going dark, they shut the doors, they turn off the lights, they're probably still paying rent. Another problem is actually in your DSCR test definition, oftentimes, and this is for the real legal nerds out there, oftentimes you'll see that in your DSCR test, the lender will only count rents from tenants in occupancy, open for business, and paying full rent. You can see where COVID really caused an issue here. Is a restaurant in occupancy if they're not open? Probably so. All right, all the fixtures are still there. Are they open for business if they're completely closed down because the government shut them down? That's a little bit harder argument to make. Are they open for business if they just don't want to open, either because they have no clients coming in or for other reasons? You know, reasonable minds can differ. Possible fixes going ahead. We've actually seen people in the cash sweep triggers, in the DSCR test, say, okay, if there's a negotiation, or excuse me, if there's some sort of government mandated shutdown for going dark, you know, we'll still count those rents, or we'll make some other accommodation there. Next slide, please. Finally, what we're seeing on more of the construction loan sign, expanded definitions, we're seeing the force majeure language isn't particularly changing. People aren't saying COVID-19 as a reason to have your force majeure clause kick in. We are seeing lenders give a bit more time in connection with the force majeure clauses. We're not seeing anything with respect to final completion dates. Those are kind of where they are. And finally, as I'm running out of time, on the COVID-19 kind of carve-outs, we're seeing relief for existing projects for new construction loans closing, and we're seeing quite a few of those. The COVID risk is sort of built in. People see that as, okay, you're coming to us, this is your plan, you should take COVID into consideration. And with apologies, as I think I've gone over my time, I'll pass it on to our next presenter.
Thanks, Dan. Well worth the extra couple minutes there. Next slide, please. As I mentioned before, I'm a partner in the construction group. I primarily represent real estate developers and facility owners, and my practice focuses primarily on drafting and negotiating construction contracts, construction management contracts, design build contracts, and design contracts for all types of projects, whether it's an office building or a professional sports stadium, really in any jurisdiction in the U.S. What I always have as my goal in the contract is a fair and equitable allocation of risk. And the same holds true with respect to risks and responsibilities concerning COVID-19. The problem I've seen in the last 18 months is that we're often using template contracts and they just don't adequately address the risks and responsibilities around COVID-19. The solution that I've come up with is to prepare a set of COVID-19 clauses that I put into the construction contract. It's maybe 6 subsections, no more than half a page, 3/4 of a page, and it places in one area all of the language and rights and responsibilities about COVID-19, which I found is much better than trying to perform microsurgery throughout your construction contract, where you're bouncing back and forth from section to section, adding a phrase here or a phrase there. Next slide, please. So with respect to the custom COVID-19 language that I've developed, I wanted to walk through some of the main provisions that I've been using in a number of projects. And this has been on private projects as well as some public projects for foreign governments with embassy jobs in the district. And I'm hoping that these will create some ideas that you might find helpful for your contracts as well. Like a building is built on a foundation, for the contract, our foundation is really the definitions. So I start with some key definitions around COVID-19. 2 of them I put up on the screen, which is a COVID-19 condition and an unknown COVID-19 condition. The COVID-19 condition has 3 parts to it. One is a public order or mandate from an authority with jurisdiction where your project is located that has a bearing on your construction project in COVID-19. So this could be social distancing, the use of PPE, or other types of issues. Another item that will be a COVID-19 condition is a supply chain disruption, specifically due to COVID-19. And the third one is a catch-all, and that's a COVID-19 impact to the project not caused by the contractor or those for whom it's responsible. So we build on that, and then we move into an unknown COVID-19 condition, which is one of those things I just mentioned that the contractor did not know about and reasonably should not have known about at a certain point in time. For the lump sum contract, that's going to be when you sign the contract, and for a GMP contract, it's going to be when the GMP is agreed upon. What I've found over the course of my practice is that oftentimes the GMP comes after the contract is signed in a GMP proposal, and then it gets pulled into the contract through a GMP amendment. So when that happens, that would be our point of time. So one quick example would be, we have a lump sum contract, we sign it today, and the contractor is on notice of all of the public orders that are in place about COVID-19, and those won't entitle it to relief. But if next week a new one is issued, that would be an unknown COVID-19 condition. Another example would be in a couple of weeks after signing the contract, the port in Italy undergoes a delay because of COVID-19 and they don't ship out the marble. Now, if that delay was known about before we sign the contract, it's not going to be an unknown COVID-19 condition. So that's how we treat that type of issue. We then move into some specific rights and responsibilities. The first one being delay. So we have language that says if the contractor can demonstrate that it was delayed by an unknown COVID-19 condition, it's going to be entitled to a time extension. The big issue is it also entitled to money for the delay, extended field office overhead? And in my contracts, the answer is no. And the reason is because COVID-19 is either akin to or is a specific type of force majeure delay. And the traditional approach in the construction contracts is that because force majeure is not caused by the owner or the contractor, it entitles the contractor to a time extension, but not additional money. The next issue is going to be addressing direct costs due to COVID-19. So this is going to be an increase in the cost of materials or perhaps shipping premiums. We're not talking about delay, we're talking about direct costs of materials and things of that nature. And if the contractor can demonstrate that there has been an increase in this direct cost by an unknown COVID-19 condition, again, we have that timing mechanism in place, then it will be entitled to additional money for that additional cost. In the GMP contract, I specify that if there's available construction contingency money, that we're going to use that as our first source of funding for these types of costs. And only when those funds have been depleted would the owner issue a change order increasing the GMP for those additional direct costs. And then the final point is burden. It's not just an issue for contractors, but any party that's pursuing a claim or is seeking relief has the burden of demonstrating its entitlement to that relief and the amount of relief. So we put into our language here that the contractor has a burden of demonstrating that something is a COVID-19 condition, an unknown COVID-19 condition, and then the cause and effect to the schedule and to cost. Next slide, please. Next slide, please. There we go. Let's stop on that one. So change order riders, the issue here is we signed our contract, we're progressing through our project, and we have change orders. We have them on every project, it seems like, and the owner and the contractor have agreed on the underlying price and schedule adjustment because of the specific change order work. But what I've seen a lot in the last 18 months is that the contractors are including a reservation for their right to recover additional time and money to the changed work if it's caused by COVID-19. And it's just too open-ended and vague. It's not limited in time. You know, when did the COVID-19 condition arise? So what we've been doing is drafting a one-page rider for change orders that addresses COVID-19. And it's in many ways quite similar to the underlying contract, but it's addressing the specific change order work. So we want to lock down the terms and conditions for additional time and money. We're going to use the same types of definitions I talked about for the underlying contract. And a distinction here for the change order rider is going to be timing. A contract is signed, of course. So now we need to figure what's that point in time that we're going to hold the contractor responsible for what's occurred and what it should know about. And there's three main choices that I've seen, and that's going to be when the subcontractors provide their change order proposals, when the general contractor provides its wrap-up overall proposal for the change order scope, and then when we sign the change order. The further out you go as a developer, the more security you're going to have because the more things will have occurred. So you'll be able to point back and say, well, yes, but when we signed the change order, this had happened, so it can't be an unknown COVID-19 condition. That's going to be the most beneficial position for the real estate developer, is to mark that point in time when you sign the change order. And then last point on the rider is going to be delay costs. You certainly can take the same position as I mentioned in the underlying contract clause, which is that a delay to change order work because of COVID-19 is a force majeure type event, which would not entitle the contractor to additional delay costs, but it would be entitled to time. However, there's a body of law out there that talks about if a change order pushes a contractor into a more expensive period of performance, such as winter weather, although that wouldn't have otherwise been compensable because it's force majeure, it is now because the change order pushed the contractor into it. It wouldn't have otherwise been there. So there is a basis there if you choose to provide additional, if you choose to provide the right to relief for delay to change order work because of COVID-19. It's really a business point and one for negotiation. Next slide, please. And the last thing I want to mention is not legal in terms of how you can change your contract to address COVID-19, but more sentiment, what I'm hearing from real estate developer clients about COVID-19. And the overarching theme is supply chain. And one of my clients, I like the way he said it, is that the supply chain is a thunderous cloud sitting over the development world. And you wake up the next day and it's still there. It's just not clearing. And while there are certainly legitimate concerns involving COVID-19 in the supply chain, as we've seen, microchips are in almost everything, and they certainly have led to increased costs because of the slowdown in chip production, and that has in turn led to some delays on construction projects. The supply chain refrain can also be abused. We've had price escalation and we've had material shortages and delays before COVID-19, and I'm sure we're going to have them after COVID-19. So it's important for the real estate developer professional to discern what's really the cause and effect here, and to press the contractor and require, through that burden of proof language I mentioned, that it demonstrate that the actual increase in price is due to COVID-19 and the actual delay is due to COVID-19, and not for everything just to be swept up under this, it's supply chain and COVID-19. We need to see some actual cause and effect. The contractor should be connecting the dots to demonstrate that. At this point, I'd like to turn over to James for the leasing segment. James?
Thanks, David. Appreciate that. So I'm James O'Brien. I'm a real estate partner at Seyfarth in the DC office. I have, however, also practiced in New York and San Francisco. I actually began my career with Seyfarth in San Francisco. I am co-head of the leasing group here at Seyfarth. I also do acquisitions, dispositions, financing, joint ventures, so more of a generalist, but have a strong component of leasing in my practice as well. And I also want to plug our podcast, The Property Line. I'm co-host of that. And if you go to my page at Seyfarth or just search Property Line Seyfarth, you'll find it. We started that during the pandemic and have 20 plus episodes. Both Mark and Dan have been on. So if you like them, you'll get more on these type of issues. The Property Line is devoted to real estate issues. So check that out as well. So I got one quibble. We can move to the next slide, please. But I have one quibble with the way Dan set, that David set this up. He said we're going in order of the project. So I don't think we'd start with litigation. I think we'd get the bill, we get the money, we get the building built, we'd lease it up, and then the lawsuits would fly. But apart from that, I thought it was a good intro. So let's talk force majeure, as people have mentioned that frequently came up during the pandemic, certainly did in the leasing world. A lot of the cases that we saw were retail related, where tenants were forced to shut down. So in general, COVID-19 basically put force majeure provisions through a stress test. And one of the lessons that we learned is that courts are generally going to defer to the language in contracts as they're written. Particularly with a commercial lease, they're going to look at a landlord and a tenant, sophisticated parties, and their intent is going to be expressed in what's written. So I think one overall lesson is try to get your provisions written the way that you want them to be written. There are, a number of recurring, I wouldn't say necessarily flaws, but maybe inconsistencies in how force majeure provisions were drafted. It's a kind of doctrine that until March of 2020, no one ever thought would ever really be used. It was an afterthought in many contracts, and now it's under intense scrutiny. So, you weren't seeing specific references to pandemic or health emergencies in most clauses, although in some I did encounter it. That could have been the legacy of SARS. There were references to epidemics in some force majeure provisions, maybe based on that experience. One other issue with them is sometimes they would excuse performance, but not actually delay the periods for performance, which could be problematic. And many of them didn't really clearly exclude payment obligations, which was often the intent of at least the landlord. So let's flip over to the next slide, please. Okay, so as signaled by the previous slide, you want to not make those same mistakes when you're drafting your force majeure clauses. So I think it's best to include specific references to pandemics and public health emergencies. Here are some examples on this page of how you might draft those provisions. If you're the landlord, there may be the case to be made that being less specific is better because the tenants have most of the obligations in the lease, and your preference would be, sort of not to excuse them as much as possible. So the more specific you get, that may benefit the tenant. However, landlords have obligations in leases as well, including delivery obligations. So frequently at the beginning of the lease, there could be issues with construction and build out and extension of time periods for those for landlords where force majeure benefits them too. So, probably best to be specific. And as Mark hinted at, and I like his Latin, I had to jot it down, justem generis, the general follows the specific. Often courts will say, well, you've listed a handful of types of items, and then you've said any other item that's beyond your reasonable control. They'll say that's not really any other item. That's any other item that's similar to the ones that you've described here. So yet another reason to be more specific and not rely on the catch-all. And another best practice is definitely to provide for an extension of performance and not merely excuse. It can render confusion in interpreting the contract. I mean, say if you're a landlord, you have to deliver space, you've got an estimated delivery date, you've got to get it, done, say 120 days after the lease has been signed, and then maybe there's penalties that kick in if you're 30 or 60 or 90 days late. Force majeure kicks in, you're excused. Okay, well, so you're excused. What does that mean? So you're not in default for not performing, but what about those penalties that kick in? Do those get extended out, or you're excused, you're not in default because you didn't deliver the space, but now it's 30 days later. Does the tenant start getting the rental abatement that they negotiated, or does the time period for all of these things get pushed out? I think the answer you want is that the time period is going to get pushed out. So here's an example of language that you can use to make sure that your force majeure clause includes extension of time for performance, not merely excuse. Another one is to, be sure to expressly exclude payment obligations. I mean, that is sort of, as Mark pointed out, classically understood in the common law doctrines that frustration of purpose and the like are not meant to excuse payment. That should be something that could be relatively easily done. But not all, and not all of these provisions are drafted so well. And so you saw some tenants who were able to be excused from their performance because of poorly drafted clauses that weren't quite clear on whether or not inability to pay would be, excused by a force majeure event. So here are just some examples of much more specific language than sometimes force majeure provisions include. So certainly as a landlord, you might want to excuse some of the tenant's operational performance, but you want them to keep paying rent as long as possible. And tenants may negotiate otherwise, but it's good to try to be clear as to what your deal is. So start with the position that you're excluding payment obligations. And again, these are some examples. So let's flip over to the next slide, please. Okay, next slide, please. Bueller.
We see the next slide, Jim. It says COVID-19 and rental abatements. Is that what you're looking
Well,
for?
thank you, because mine does not come up on my screen. So I will go. Oh, there we go. Flipped for me. I have a cheat sheet, so I could work toward that as well. So what we're talking about tips and trends, and one of the trends you're seeing right now is what do you do with the fact that we know that COVID-19 is out there? You're entering into a new lease. Both parties anticipate that COVID-19 is an issue. There could be other pandemics, but more importantly, there could be a resurgence of the current pandemic. How do we deal with it? Well, how we deal with it is not just relying on force majeure, impossibility, impracticability, and being in sort of the mess we've been in for the last couple of months or longer, but actually negotiating up front what's going to happen. So the trend is really toward cost sharing. Both parties sharing a little bit in the pain for something that's sort of outside, that really is outside of both of their control. So some things I've seen recently, an initial rental abatement period for a retail or restaurant operator, or other tenants that are challenged, but they want to get in the space and they've got good long-term prospects. This can be a sliding scale. I'm doing a deal right now where the tenant has a 100% rental abatement for the first couple of months, then a 50% rental abatement, then 25%. And, that's really just the landlord trying to incentivize them into the space, and they're going to be there for, 5 to 10 years. Sharing that pain in the short term is good for them. Also, you can have a rental abatement triggered later. So instead of just relying specifically on force majeure and figuring out what happens, you actually have a rental abatement provision drafted that said if there's a government shutdown order or some kind of capacity limitation, we're going to have an abatement kick in. As the landlord, you want to be very specific about this. It'd be good to have, your language narrowly drafted so the tenant is really mandated to shut down as the trigger. And again, these can be sliding scales, and the duration can be limited. For example, there may be a bigger abatement for the first couple of months, and then it ramps down over time. And then at a certain point, the tenant has to decide whether they're staying or going. And so either they commit to the space and they start paying rent again, or they can terminate the lease, perhaps. So that's the rental abatement period followed by termination right for either landlord or tenant that we're seeing. Another common exercise during the pandemic was to do rental deferrals on a short-term basis. Some of those are being built into leases up front. So instead of excusing rent altogether when there's a triggering event, you defer the rent to the back end of the lease and extend to the term. So as a landlord, you're sort of getting the economics over time that you wanted, even though there's some excuse for the tenant up front. So we'll go to the next slide and see if my computer catches up. If not, as I said, I have my own cheat sheets.
Yeah, we're there. We see it.
Okay. Thank you. Mine hasn't flipped over, but we're talking other provisions in leases that could prove problematic and that you might want to look at. One is the permitted use provision. I haven't seen a lot of people making changes to their lease because of this, but I wanted to highlight it. We talked about the Cafe Nero litigation. That was one where the tenant made an argument that the purpose was so narrowly drafted and the permitted use was so narrowly drafted that the entire purpose of the contract was affected by and frustrated by COVID-19. They were to operate a sit-down, they were to operate a cafe. It's basically like a Starbucks, and they could only do takeout from a sit-down menu, implying that they had to have a sit-down menu. When they were closed down, there was an argument they couldn't meet this requirement in the lease that both the landlord and the tenant had agreed on, and therefore, it was clear that the negotiated purpose of this lease was frustrated, and the tenant won in this case. So maybe just adding a little bit of flexibility, even if it's at landlord's discretion, could help defeat this argument. In addition, cotenancy, as you heard about in Mark's presentation, the issue with cotenancy is that it's not really drafted as a landlord obligation. So say you're in a shopping center with Target as the anchor tenant, Target closes down. The way most of these clauses are drafted, it gives the tenant an excuse if Target closes down. It doesn't say if landlord has to use its commercially reasonable efforts to make sure that Target remains open. If that was the case, then the force majeure provision might be able to excuse the performance of the landlord, but that's not how they're usually drafted. They're more an objective standard. And these can allow tenants to close their businesses down, to get abatements of rent, to potentially terminate leases. You want to see if you can attack those provisions. Mark mentioned a few methods of offering landlord protections, but one of them is to tie this directly to the same sorts of triggers that you would have for force majeure. So, mentioning within that provision that if Target is closing down due to government mandated order, that is not going to be a trigger for the co-tenancy provision that would enable the tenant itself to have a rental abatement or a potential termination right. So two other provisions besides force majeure and to be aware of permitted use and co-tenancy. I realize I'm in kind of the sweeper position here, and we don't have a ton of time, and we wanted to take questions too. So I've tried to condense as much as I can. If you do have questions, feel free to throw them into the chat. I see a little red dot down there, so somebody's got questions. But I think we're going to roll through from the top again, starting with Mark, if there's any questions about litigation.
Sure, let me jump in first with our CLE code for the attorneys out there before we move into the Q&A. So you're going to need to include this code on your CLA verification form, which is going to be emailed to you following the webinar. And the code is SS, which is for Seyfarth Shaw, and then the number is 8299. So once again, that's SS for Seyfarth Shaw, 8299. Okay, so let's go into questions. We've got a few minutes. We'll continue to go. Perhaps everyone will take one question. And as stated before, if we don't get to your question, feel free to reach out to us. I'd be happy to talk to you offline as well. Yeah, okay, so that's going to be you first, Mark.
And you're on mute.
I see a question here about decisions in these contexts relating to office tenants and their obligations to pay rent during COVID. There have been a lot of lawsuits filed. There really haven't been a ton of decisions that have come out. A lot of them, I think, are going to be the product of settlement discussions. One that did come out the last December, I don't have the citation right now, but I can certainly provide it. Bobby Flay is an office tenant in New York, and he's a famous restaurateur for you folks out there in the New York area. And he had, his business, his customers were the restaurant industry in terms of what he supplied to, catering and all that. And he actually filed a lawsuit contending that he was excused from paying rent because of the government shutdown orders. Now, he wasn't shut down from using his office space. He argued that his tenants, his primary customers, restaurants were closed. And we actually, Seyfarth represented the landlord in that case, and the landlord prevailed, and the court ruled that no, that's too extenuated of a reach. You weren't prevented from using your office. You may have voluntarily shut down. You may have voluntarily furloughed your employees and let them work from home, but you still had use of the office space, and so the court did not allow him to avoid his rental obligations. But we've seen a lot of law firms, Jenner & Block and other law firms throughout the country have asserted these defenses, but they're still wending their way through.
Thanks, Mark. Picking it up, I didn't see a finance question on our list here, but an observation just in listening to my co-presenters and seeing what they were saying. This is all kind of new, and it hasn't yet shaken its way through the entire system. There are gaps, there are discrepancies as between what you might be seeing in a construction contract or what you might be seeing in a lease with respect to the liability of the owner and what you might be seeing in a loan agreement. I think the next, hopefully short period of time, but certainly over the next couple of years, we're going to see all of these provisions further evolve as I guess leverages change between the various market participants. But be aware of them in the interim that there are risks for owners as these provisions do evolve and work their way through the market.
Okay, I'll take the next one for construction contract related questions. And here's one about what's the most contentious point you've encountered in negotiating the custom COVID-19 language, and what are some alternatives or potential solutions? The most contentious one has always been whether the delay due to a an unknown COVID-19 condition is compensable, whether the contractor recovers its field office overhead. So in terms of some alternatives, without just saying no, that could be considered, one would be to use a bit of a holiday. So you could say that the first X days of that delay are non-compensable, 5 days, 10 days, whatever you might think is fair with your contractor. And then after that, it would be compensable. So that's a little bit of a middle ground. And you can also look at limiting the compensation to the direct cost of the field office overhead and not including the typical markup percentage on top of it. So at least the contractor would be made whole for that period that you make compensable. You're up, James.
Okay, so in the leasing context, so one question is, are you seeing the same changes to force majeure and COVID-19 abatement provisions in office leases that you're seeing in retail leases? So I guess the answer to that is both yes and no. The short answer is yes, I am seeing that, but the longer answer is there's not that many office leases. The office lease market is slow. A lot of my clients are looking to try to sublease. That's further driving down rents because the sublease market is flooded. So you're seeing, only sort of, well-heeled, think maybe like Fortune 50 type companies with specific needs and a lot of cash entering into new office leases, or I have one client who's been extending leases at a lower rental rate across its portfolio. And that tenant is seeking, in an office context, the same sorts of cost-sharing type rental abatement provisions related to COVID-19. And generally getting them because they're one of the only office tenants out there looking for space. So this particular client is in California, and in California there was a whole color-coded system of reopening, red, orange, yellow levels, and they drafted a pretty creative provision about, depending on what colors we were at, whether they would be entitled to a rental abatement after a certain period of time. There was often negotiation, like I said, about the sharing and that, how long would it last, and how much would it be? But yes, they were able to get it.
Okay, well, I see that brings us to 2:02 Eastern Time. That concludes the webinar. We'd like to thank you for taking time out of your day. We very much enjoyed talking with you about these issues. And if there is follow-up, if you have questions for any of us, please feel free to reach out to us, and we would love to talk to you. Hope you enjoy the rest of your day. Thank you.